All right, this is for the introduction class, and this is for the law of business for chapter 14. And I'm just going to go through it very quickly since, again, we're doing just an overview. And we will actually do business and organizations. It's combined currently with the contracts class that'll be happening in the spring. And I wanted to say that we are working on kind of splitting those two out into individual classes. All right, so first is the definition of agency, and that is two parties where you have the principal and the agent, and that'll make more sense in just a minute, who agree to form a mutually beneficial relationship. Then you have your fiduciary, and that's a person who has the obligation to act for another under circumstances that require trust, good faith, and honesty. So let's talk about these a little bit more in detail. So, agency, it is rooted in business, contract, and tort law. And you have principals and you have agents. The agents are the people who are designated to hire or to perform things, tasks that are on the owner's behalf, and they have the fiduciary role. And don't worry, I'm going to give you examples so it'll make sense in just a second. The principal is going to be the one who controls the actual relationship, and that's because they're the ones who reap most of the rewards. And again, you'll understand what I mean by that when you see the examples. Hence, the reason it's called a beneficial relationship. The agent is empowered to carry out certain tasks on behalf of the principal and also to benefit them. So to create the agency relationship, you have to have that manifestation of assent. Think back to contracts where we talked about the fact that you have to have a valid offer and you have to have a valid acceptance, and there has to be consideration, and those come together and they make that mutual assent. It creates that meeting of the minds. It can be oral, or it is always best to cover your butt and have something in writing. It can be implied. And when there is an implied agency creation, that is going to be for the finders of fact, which would be your jurors, in the event that there is a dispute. Now, both parties do have to be legally competent, so no legal disabilities that would affect the creation of the agency. And they have to be above the age of majority, which also goes back to contract law. All right, so the agent has 5 duties. They have the duty to comply with the principal's lawful instruction. So that's part of the contract, is to follow what the person is wanting. They have the duty of care, competence, and diligence, and this has to be something that's just reasonable. Again, that's one of the words that I always go back to: knowledge, intent, and reasonableness. They have to have the duty of good conduct. And that means that they are not going to be doing something that is going to injure the principal. Okay, they are going to be acting with good faith, and they will be, keeping, they're going to keep the principal's money out of their own money, or, any kind of property. They're not going to commingle. They're not going to say, hey, this is my own. They're not going to do any of those things. They're going to keep track of whatever it is that they're doing, and they're going to give the principal any kind of relevant facts and information that they may need. So they have the duty to act in accordance with the express and implied terms of the contract. So that goes back to following, the instructions and whatnot that are put in there. And then they have the duty of loyalty, which means that they're going to push their own interests aside, and they're going to be doing what they need to do in order to fulfill this agency relationship. So let me give you some examples. So hopefully it'll help make it a little more understandable. A hired B to contact 5 vendors on behalf of his company. The list. And after B finished, he thought of another company that might work well. He contacted that company as well. So what's wrong with that particular scenario? You have somebody who failed to act in accordance with the expressed and implied terms of the contract. And I know that doesn't seem like it's anything bad, because let's just say that, he thinks of this other company and it's something that's positive. They're like, yeah, we'll take, 20 of those. It's not like the person's probably going to mind, but just keep in mind that scenarios that you're given when it comes to the law are just simply to represent what it is that we're talking about kind of in its purest form. Okay. Hopefully that'll help, make it make sense, because I know that when I was writing some of these, I was sitting there. I always try to argue both sides in my head anyhow. And I was sitting there looking at it. I was like, there's nothing wrong here, but there is technically, because again, we're going with that purest form. All right, so A works for Jones Construction as a full-time estimator. He took a job at Smith Construction to help him pay for some recent medical bills. At Smith, A is an independent contractor who is doing some estimating. Both companies were bidding on the same public school. He did not disclose to either employer that he submitted bids for both companies. When A got caught, Jones Construction filed suit in tort. So what is wrong with this particular scenario? And this is an example of where he breached his duty of loyalty. And hopefully that makes sense, because you actually do have a lot of people who will kind of moonlight at another company and not tell them. And they'll in turn, if something happens, they will ultimately be in trouble for it simply because they're working, also with the competitor. All right, so we have the definition of indemnity. Don't worry, we're not finished with agency yet. And that is to compensate the other party for losses or damages that have occurred or will occur in the future. So the principal's duties. They have the duty to act in accordance with the express and implied terms of the contract. If they do not, it constitutes a breach of contract. They have a duty to indemnify the agent, and they have the duty to deal fairly and in good faith with the agent. So they are going to have to refrain from acts that are going to cause an agent to have a loss and where the agent is not at fault. So let's talk about some examples. So you have A hired B to be his agent on a land project. A owned a tract of land and wanted it subdivided into 80 half-acre lots with an allowance to be given for the roads. B's job was to plot and create a map for the neighborhood. B spent time and money on getting started when A sent B an email stating that he had changed his mind on the development, and B sued for breach. What's wrong with that scenario? That is where you have the principal who failed to act in accordance with the express and implied terms of the contract. He backed out of it, and he backed out of it after this work had already been started. And I know this probably sounds a lot like contract law, and it is contract law, but it's not where you have like a buyer and a seller or necessarily a service that's being provided to somebody, like to a customer. This is an agency relationship, and it's going to operate in a little bit different way, even though this guy is providing a service. So A was redoing the landscaping on his yard. Due to the drainage issues, A hired B and C to dig the ditches for some drain pipe to go in. When C started digging, he cut the phone line. A did not tell him about the utilities that needed to be avoided. The phone company sued against B and C, and they filed for indemnification. So, should the indemnification be granted in this type of a situation? Yes, it should. And that's because, again, remember, it's about compensating somebody for those losses. And in this case, they were not told. So the phone company should have been suing A, because A had the duty to make sure that they knew where those utilities were. So when it comes to agency, there are 4 types of authority. You have the actual, the apparent, the inherent, and the ratification. Let's talk about what these look like, and I'll give you some examples thrown in there too. So actual authority is where the agent takes an action with the reasonable belief that the principal wanted it. Express is where they're told exactly what to do, okay? This is where it's going to be spelled out precisely. I want you to do X, Y, or Z, or and Z, actually. Implied is where they're going to act reasonably necessary to accomplish this objective. So let me give you 2 examples. A hired B to sell his vacation home in Montana. It must be sold within 6 months, and it cannot be for less than $1 million. This is express. We know that he's selling the home. We know that it has a time frame on it, and we know that it is less. It cannot be. It has to be $1 million or more. Okay, so this is going to be an example of the express one. But let's look further. A hired B to sell his vacation home in Montana with no further instructions. So B has the power to put the property on the market, negotiate with interested parties, and accept offers. There's no time frame, and there's no money amount here. So this is going to be an example of implied. All right, apparent authority is where it exists where an agent acts for a principal with a third party that reasonably believes the agent has the authority to take. This is where you're going to have somebody who holds out like this representation of who they are, right? And the belief is going to result from the principal's action or inaction, and the principal must be disclosed or at least partially disclosed to the individual. Let me show you what that looks like. So A is a manager for a general store. She is allowed to negotiate terms with vendors, but she cannot sign the purchase agreements. Once they are sent to her, A transmits them to B, the owner, who is the only one who signs them. A is the only person that the vendor deals with. And one day, A is very busy and signed the purchase order herself. So would the company be bound to this particular contract? And yes, it's because there is that apparent authority there. Again, if you go back and you look at the slide before, it talks about the fact that there's this representation, right? The principal has to be disclosed, and it has to be what the person on the other side, the third party, reasonably believes. So they know that A is just the manager, right? So they know that there is somebody who is an owner or at least above her, right? They also know that they have dealt with her in that capacity. Now, the third party doesn't necessarily know what goes on behind the scenes. They don't necessarily know that part of A's job is to transmit it to B, who's the only one who can sign them. That's not the fact that matters here, because we're talking about what this third party could reasonably infer from their, their history of dealings with, this particular company. So all they know is that, yes, they've gotten purchase orders back and they've been signed by B, but they don't know that that's the only person who's allowed to do it. I mean, if they do know that, then that's a different story. But for the purposes here, let's just assume that they don't, okay? Again, you have this representation that they're seeing that I deal with this person, I give them the purchase agreements, and then they come back to me signed. Yes, they get signed by somebody else, but again, it's that's not on me, right? So this would be one where the company would be bound because of that apparent authority. All right, so inherent authority, I don't even know why they still include this, because it is no longer recognized by the restatements. And but it is where the person had the power to act for the principal and was not express or implied. And it arises only if required to be done for an agent to exercise any actual authority. And before we end up moving on, I've got one more. I'm going to talk to you about ratification. And then I'm going to kind of circle back and make sure that you fully understand this whole agency type thing. And finally, we have the ratification. And that is where agents are limited to binding the principal per their authority. So you might have an agent who does exceed their authority, and the principal, they either, if they accept it or they take advantage of it, then the principal is going to be bound. And it can only take place if the principal has been disclosed or has been partially disclosed. So an example of this would be like, if you have a situation to where the principal has authorized their agent to let's say that they are at a car dealership, right? And they have authorized them to do some certain type of special financing for people with bad credit, right? And the agent comes back and offers them some kind of different deal or offers them a different, type of financing. The principal at that point has to come in and they have to give some kind of protest. They have to be like, no, we're not going to do this, right? If they don't, then it would be considered ratifying the deal, and it would end up going through, and they would end up being bound to the contract because there was nothing that was said. So another thing I want to say is that when you're talking about this, this implied authority, not the implied authority, the apparent authority and the actual authority, and then the ratification. Let's talk about if you have somebody who has rental properties and you have somebody who's living in it, and your tenant has let's say that their kitchen faucet goes out. Well, let's say that they have, in the contract, it states that they can do minor repairs, and that the agent can do the minor repairs up to, say, $75 without permission, right? So they go out and they get a new faucet and they come back in and they install it and they send the bill. Okay. So that is where there is express authority that has been created because there is a limit that has been put on it and they know what it is they're supposed to do. They're supposed to go get it, pay for it, submit it to be paid back. Let's say it's a little bit bigger than that though. Okay. Let's say that you have a situation to where maybe you have you have to call in a plumber, right? And because maybe there's something that's actually wrong with like the pipes that are coming into the kitchen. So in that kind of a situation, you might have the plumber who comes out. And when the plumber comes out, they don't necessarily know that the person that they're doing business with is not the actual owner, right? That is where you have to look at what the person believes on that other side, that third party. That's where the binding effect is going to come into play. So if they have a situation to where the plumber comes back and he says, listen, it's going to cost $250 to fix this. Well, let's say that the contract states that, you only have to get permission for anything over 200. So you know that you have to get permission for it, right? In that kind of a situation, plumber doesn't know that. They don't know what the terms of your contract is. All they know is that you're acting on behalf of the property itself, right? They don't know anything else above and beyond that. So in that situation, if you have the tenant and the tenant says, you know what, hang on a minute. You know what? I need to call my landlord really quick. All right. So now you have disclosure, right? And then you have this situation to where maybe the landlord comes back and says, okay, well, now the authority, it's good and it's going to be bound. But then you might have a situation to where maybe the owner can't be gotten a hold of, or maybe they don't say anything about the owner and they just go about it because maybe it's an emergency situation. You're like, look, just go ahead and take care of it. In that situation, it's going to be up to the tenant and the owner to then have, basically kind of duke it out over if the bill is going to end up being paid or not. Now, in that type of a situation, if the owner does not do some kind of protesting, if the owner does not come in and, have something, I don't know, maybe something got installed and they're having it removed or whatever, and they're going to have it, properly put in by their people, something, along those lines, then you have a situation to where if it stays in place, if there is no protest, if there's absolutely nothing that happens, then it's going to be considered ratified. Now, in a situation like this also, it could be argued, because remember I told you, I try to look at both sides of things, right? It could be argued that, let's say that the owner calls the plumber and is like, you were supposed to get permission from me. They don't know that. They don't know that at all. Okay? Again, it's not their responsibility to seek out what the terms are of every deal it is that they're doing. So in that particular case, if it went to court, the principal is going to end up being bound even though the agent went over. Now, does it mean that the agent might not have to pay that additional $50? They might. But again, they're at least going to be liable up to that $200. And here you go. I forgot I even had this in here. So in regards to the principal's liability for the agent's actions in contract, they are going to be liable for all agreements if there's express, implied, or apparent authority to enter. Again, they're going to be bound. It doesn't mean that the owner can't go back and try to hold, the tenant liable for a certain portion. But again, that's a different situation. In tort, they can be directly liable, and torts, and remember, are personal injury type things, if they were hired to commit the tort, and they can be vicariously liable if it is done during the course and scope of the person's employment. And that's pretty much it for agency. Let's move on to formation. This right here is just a chart that basically sums up everything I'm about to tell you. All right, the definition of a sole proprietorship is someone who owns an unincorporated business alone. So the characteristics that you're looking for here is going to be that the ownership and operation, it is going to be that one person typically. They're going to be the owner and the operator. Taxation is going to be at the same rate and manner as the owner, and that's because this is where you do business basically in your own name. Now, you can have a business name, but it's done usually by filing a DBA, doing business as, with the courts. So you can still get paid as the DBA, but most people still, put it into one pot. They will pay the operating expenses from the gross of what they take in, and then whatever's left is their actual income. And then liability, it is totally inseparable from the company. You open yourself up to so much liability in these types of situations. Anything that you own is fair game if somebody comes and sues you. So just remember that. Capitalization is going to be what the sole proprietor, that individual, is going to be putting into it. And in terms of liquidity, it is fully able to be sold without any kind of hindrance whatsoever, and it would be done and over with. Now, the definition of partnership, it is a for-profit business organization that is comprised of 2 or more persons. The definition of a pass-through entity, business forms whose liabilities, that's their tax obligations, pass directly through the organization to the individuals who own the company. And this is specifically used for partnerships, LLPs, which are limited liability partnerships, an LLC, which is a limited liability corporation, or an S Corp. That is the a version of the incorporation or the INC. So now partnerships go back to the laws of agency, like we just talked about, and contract theory. And they can be very simple where, you have this partnership of you go and buy me groceries, or it can be complex of company A and company B merge and each has over 50 partners and they can maintain it being an actual partnership. Now let's talk about the characteristics of a partnership. So with formation, it is simply just a contractual capacity. Most states don't require them to have to register with the state, so hence the reason why they have that contract going on between them. The ownership and operation, that is going to be by the partners. They are going to both own and operate. The taxation is that it is a pass-through entity. The liability is that they each can bind the other person. So if you have a partner who goes out and makes contracts for you, well, guess what? You're bound to it because they have the ability. Remember, go back to that agency relationship and how it's about that representation and what that other person believes, not what they know. Exception is going to be criminal liability. Capitalization, it is done by contributions that get paid in, and liquidity in that particular case is going to be only their own interest. They cannot, they cannot go and sell the full partnership. They can only sell what it is that they own. Now let's talk about these in a little more detail. So with formation, because again, it's going to be agency and contract theory, we're looking for the age of majority, which is 18, and they have to have competent individuals. There is no formal writing that is needed, but I will say this, it is always best to have whatever written down because that is something that, is easier to prove what it is that the assumptions you basically both were operating under. Some jurisdictions do want the filing of a partnership agreement, and that would be with the Secretary of State. And you can have a partnership by estoppel, and that is where the partnership has been inferred by actions like holding themselves out as partners, sharing profits, losses, etc. As a matter of fact, I can give you a really good example of this one. So there is this lady that I know who was starting a streaming service, and she was having all kinds of people, who do podcasts and, have YouTube channels and stuff like that. They were coming in and they were allowing certain material to be put onto this streaming service. Anyhow, she had a partner when she originally started this, but that partner actually ended up dying. And anyhow, so she kind of, put things off for a while, and then she came back at it and she took on this new partner as somebody who was going to be helping her with this. Now, again, there was nothing that ended up being, written between them. And just in this past week, they ended up having a situation to where the new partner fled and started her own streaming service. And now she's she's like trying to contact all the people, and she's trying to lure them over to her service. She took all of the first lady's documents and everything. So in this particular case, even though they did not have an actual agreement like written down or anything like that, they did hold themselves out as partners. They held themselves out on social media, like, hey, yeah, make sure you talk to my business partner, things like that. So even if they had absolutely no agreement whatsoever, it could have been inferred by things like that. Because remember, it's going back to what that third party would believe. And would somebody who is reading who's reading a post on social media of somebody who's saying, talk to my partner, would you believe that they're not partners? No, because why would you? You're there to believe what it is that they are saying to you. Another really good example. So I don't remember if I've talked about it in this class or not, but credit repair is illegal in Georgia. And anyhow, it's only illegal though for certain types of business entities. And one of the entities that is allowed to do it is a lawyer who's doing business during the course and scope of their normal practice. So there was this guy, and he was going out and he was holding himself out to have, the only legal type of business basically in Georgia for credit repair. So what ended up happening, which that wasn't true, because there's like 8 different types. You can have somebody who's like a mortgage broker, somebody who has an SEC license, things like that. Those are going to be people who are also allowed, plus a nonprofit. Anyhow, so he's going around and he's telling people that, the way that you get around this is that you have this partnership with an attorney, and the attorney owns 51% of your company and you own 49%. Anyhow, that is a big no-no right there. But there was a situation to where they got reported to the Attorney General. And it was because they started, it was a multi-level marketing thing. But anyhow, what happened was the Attorney General's office said, because there's a lawyer involved, you have to go through the state bar first. Then after the state bar does their thing, then we can wrap it up. So anyhow, I got to work on this particular case, and it was absolutely hilarious to me. So, this is one of those things I love too. I can't express to you enough how much I love doing things like discovery and like pointing out. I like telling people they're stupid without telling them they're stupid. That type of a thing. So anyhow, what ended up happening was the complaints were filed with the bar, and they had to wait, to see what came back. So the first thing that came back was the rebuttal by or the response from him stating that he would not operate in unauthorized practice of law anymore. He was signing the cease and desist. Then hers came back, and she came back and she said, we're not partners. She's like, I don't even know this guy. And she said, he hired me one time to do one thing, and that was it. She said it was to speak at an event. Oh, Lord, let me tell you something. If you're going to do something on social media, you make sure it's private if you don't want it to end up in any kind of a court filing or anything like that. Because what I did was I went and started looking at social media, and he had a video where they were talking about they were partners. And so anyhow, he's sitting there. He was like, yeah, we've been partners for what? And she goes, 3 years now. He's like, yeah, 3 years. And then, he introduced her. He's like, this is my partner. And there's a whole lot of partner. Anyhow, so when we sent the response back, I included that video. I put it up on a YouTube link, and I made it private. And I made it so that I told him exactly what minutes and seconds to go to in order to rebut every single thing that she had said to them. She lied to them, straight out, just lied to them. But again, this is where there might have been absolutely no agreement that actually existed between the two of them. But again, this is where that third party, which would have been the bar, could have looked at it and said, y'all were definitely holding yourselves out as partners. Okay. And he's talking about the fact that you own 51%. And he owns 49%, which means that you're sharing in profit and losses, which is a violation of the bar rule, because attorneys have to do credit repair work within the course and scope of their normal law practice and under the bar rules. In the course and scope of a normal law practice, they cannot split fees with a non-attorney. They can only split certain types of fees with other attorneys, and he was not an attorney. And this was not in the course and scope of her normal practice. Anyhow, so she got busted for that. I don't know what ended up happening to her, but she had some other complaints that were before them for other things as well. But I just wanted to give you another example because, again, it's about that third party and what can be put together. And again, if they're holding themselves out as it, we have no reason to do anything other than to take them at their word. All right, so the ownership and operation, this is where you have them originally pay into the partnership, and that money does become their general interest in it, and that money gets held in a capital account that they would have debits and credits basically go into as there are profits and losses. Property is the partnership's unless it is somehow noted on the title or in some kind of a contract that states that it is not. They have the equal right to participate in the management, the day-to-day management of the partnership, and profits are split equally. Now let's break this down a little bit further. So you have the general partner, who is a person in limited partnership tasked with the management of the firm and is vested with full authority to make all business decisions. Then you have a limited partner, and that is typically an investor in a limited partnership who is allowed no active role in management. Let's talk about what this looks like. In a limited partnership, this is a modern form of the partnership. And the general partner is going to be the one who's going to take on the liability when it comes to any kind of debts or obligations that the partnership incurs. Now, remember back to the general partnership that we talked about before, that is where they split it equally. Not in this case. The limited partner is going to be shielded from liability, but only to the extent of what they contributed into the partnership. So if they invested $100,000, then their liability would be up to $100,000, and that's it. So it's got to have at least one general partner and one limited partner, and they are specifically limited for companies like law firms, and they are not recognized in all states. So the characteristics you're going to be looking for is that they are state regulated. So these will get filed with the Secretary of State. The ownership is going to be split, where you have the general partnership or the general partner and the limited partner who is going to have, the ownership rights, but they're not going to have the same operation. Remember, that is solely on that general partner. Where there is no agreement that exists, it will be considered 50-50. Otherwise, it'll be proportioned out to basically whatever it is that they pay in. Liability, again, the general partner has that unlimited liability, and the limited partner is going to be just to the extent of whatever they put into the business. Taxation, it's going to pass through, to them based on whatever their percentage is. So if it's 50-50, then they'll get it 50-50. Capitalization, it's the same as the general partnership. Liquidity, they have the right to transfer their interest, but the new owner is not a partner unless the agreement gets altered. So that's a different, little nuance to that as well. Whereas in general partnership, they would be. All right, now we have the corporation, and that is an independent legal entity that is separate and distinct from the individuals who own and operate the company. All right, so the characteristics that you're looking for is that it is a legal person. It is a living, breathing entity just like you and me. It can, pay taxes. It can tax people, and collect for the state, of course. It can sue and be sued, and it can be held accountable for any kind of criminal conduct. It can also last into perpetuity, and that's because it does become its own person. So basically, it extends beyond the people who actually created it. It does limit the liability of the shareholders. It is typically, management is supposed to be separate, but that's not always the case. And again, this is going to come back to their articles and their bylaws. But so it can be run by shareholders, and it can be run, by a person who's a part of the board of directors and who's also, say the president. All that's fine. It doesn't have to be separate, but the idea of it is at least separate. It can be freely sold or gifted, and the operations are limited to what the articles in the bylaws say. The articles are going to be the articles of incorporation, and those are the documents that get filed with the Secretary of State. Sometimes some jurisdictions require the bylaws to also be filed, and that'll be more about your operating procedures. So in creating a corporation, it is governed by state law, and the majority have adopted the revised Model Business Corporations Act, which does help make things a little more uniform. A lot of times people will be looking at places like Delaware that are very corporate friendly when it comes to creating their entities. If you do something like that, then in Georgia, if you're here, you would have to put the corporation as a foreign entity with our Secretary of State if you're actually doing business out of here. So promoters are part of the pre-incorporation part. And your book says that that's a way to form a corporation. And it is, but it isn't. They're basically the people, and it can be people who end up being, like owners and stuff like that. But they're the ones who are going around and they're seeking investors and they're seeking people to come in, and they're also entering into contracts. Like, for example, they can be the type type of contract where they're like going ahead and setting up a brick and mortar type presence. So they're entering into a rental agreement, or they're setting up with suppliers who are going to end up being their vendors, things like that. In these situations, they do remain personally liable for the contracts unless the corporation does a novation, which is where the corporation would step in and take over the contract. So the de jure corporation is a corporation by law, and legal rights to exist cannot even be questioned by the state. A de facto corporation is the legal recognition of a corporation, even if the articles of incorporation are not properly filed. Corporation by estoppel is the course in dealings with a business as if it was a corporation. So let's talk about these a little more in depth. So you have the de jure corporation, and again, it's a corporation by law. It has complied with all the requirements. So like in Georgia, when you're filing one here, you have to file your articles of incorporation with the Secretary of State, and it has to be, filled out with a registered agent. It has to have, who the people are, and then you have to pay the requirement. And after you do all that, then you would get the certificate of incorporation sent back to you. So the de facto corporation is created from taking steps to incorporate, but it doesn't fully comply with the state laws. And there's no protection when it comes to a quo warranto proceeding. And that basically translates to by what warrant can you hold an office? And that's where the state would kind of pull you in and be like, what's going on? Are you legit? And they're going to be questioning it. They are going to be protected, though, against third parties. In these particular cases, they must have the statute for incorporation to be possible. There has to be a reasonable attempt to comply with those statutes, and there has to be some actual use or exercise of corporate privileges. So let's say that you are planning to incorporate your business and you are relying on your assistant to be the one to do the filing for you. And you've given all of the information, and you've given, a credit card or whatever to file the filing fee once they're done. But you find out, say 6 months later, that it never actually got filed. And you've been holding yourself out as a corporation. So in that particular case, you would be considered a de facto corporation because you've been operating for 6 months as if you exist. The statute does exist, and there was a reasonable attempt to comply with it. You just didn't know that the secretary did not end up following through. So corporation by estoppel, that is where you have dealings with a third party who believes it's a corporation. They are estopped from denying any kind of corporate status, and they cannot claim that they are not dealing with corporations after having a belief that it was. And this is going to be set up where you're looking at a situation to where, what does that third party think, right? And in that particular case, if they believe that they're dealing with a corporation, then they're going to be able to make it so that they have corporate status that's going to get applied in the event that there is a dispute, and it'll be dealt with in that particular way. All right, an open corporation is an entity where ownership shares are available for exchange on the stock market. And then you have a closed corporation, and that is where you have an entity whose ownership interests are not available for public exchange. You have two types of stock. They're called preferred stock and common stock. Now, the classifications allow for the denial of voting rights. Preferred stocks may have superior voting rights, which means that they can vote more than once. So like their vote would count, say, for 2 votes versus the common stock having only 1. Rights and privileges do have to be laid out in the Articles of Incorporation. Preferred stock is going to get priority when it's time for dividends to be sent out. And the preferred usually are the ones who get to elect any kind of directors. So there is a benefit to having the preferred over the common stock. All right, so you have an annual meeting, and this is for the stockholders, and this is where they would vote on the election of directors, and notice is required. You might also have a special purpose meeting, and this is where you have something that needs to be changed immediately. And again, notice is required. And this would be in a situation where maybe you have a CEO or something like that who has just been in the news for some kind of, massive scandal, and you need to get them out immediately. This is how you do it. So a derivative action is a lawsuit that gets brought by the shareholders on behalf of the corporation against the officers and or the directors for mismanagement or malfeasance that caused harm to the shareholders' interest. So when a derivative action takes place, it has to be started with a formal demand in writing to the board. As you can see on here, I put some cases on here, and you can kind of look those up, and you can see what those cases are about. But the board gets reasonable time, and the board gets to seek outside counsel and or create a committee that would basically do the special investigations, and they would determine if somebody needs to be removed. Committee will make a recommendation to the board on whether or not they support the derivative action. If they say no, then shareholders can come back in and they can pursue regardless, but they have to bear the full cost of litigation if they lose. So that's kind of the benefit, is having the board on your side and having them, to help support you. These types of cases do have the same characteristics of a class action, where you're going to have, basically like your face plaintiff, and then you're going to have all the other people. After there is a determination, the shareholder turns around and files the suit as the individual on behalf of the corporation. And they have to give notice to all of the other shareholders to ask them if they want to join. And then after that, it's going to follow the normal path of civil action with filing and discovery and answers and all of that good stuff. So the corporate veil. This is the liability shield that automatically attaches to the shareholders of a corporation. So there's something called piercing the corporate veil, and that's where it makes it so that a person becomes liable even though they are behind that corporate shield. Basically, it's about breaking the corporate shield away from them. And there is a 2-pronged test. The courts will look at, is there sufficient unity of interest and ownership between the corporation and its owners such that the separate entity status of the corporation should be disregarded? And would it be inequitable to pierce the corporate veil? So is it fair? So basically what this says, without saying it, is, are they commingling their money? Are they taking in funds in the name of the business and then putting it into their checking accounts, their personal checking accounts? And are they doing things like taking property and using it for personal interest rather than for corporate interest? And in that particular case, they would be able to come back and say, yeah, well, you've commingled, so you took away that corporate protection that you needed. The court will ignore the walls of protections of shareholders when there is a fraud situation, where there is inadequate capitalization, where there is the refusal to recognize corporate formalities, when there is a liability of parties and it requires it, where there's tort claims, and where there are contract claims. When formalities get ignored, This is where you have an alter ego fact pattern, and the company becomes the second face. They're the alter ego. And the court is going to say, look, are they just using this company basically to shield themselves from litigation? Or is this an actual company, right? They'll look at, have any kind of acts become illegal or abused? And again, like I said before, they'll look at whether or not it's commingled. So again, we're looking for somebody who's basically operating a business and they're using corporate interest and assets and things like that for themselves. And that's where you're going to have that alter ego come in, because you got the person and then you've got the company that acts as their alter ego. So the dissolution of a corporation, the shareholders have to consent, notice gets given, assets get sold, there have to be no lawsuits that are pending, and debts will get paid first, and then remaining cash will be distributed to shareholders. Remember, preferred stock first. And finally, we have two types of bankruptcy that can happen for corporations, and that is reorganization, which allows for protection from collection while they are in repayment, and the creditor eventually does receive for the total amount or whatever they have, designated as an okay amount. And then you have liquidation, which is the absolute discharge of debts, and that's where you have all assets basically get liquidated and changed into cash. Now, that's it for this particular lesson. If you have any questions or concerns or anything like that, please reach out and email me or call me. Bye.